Hello everyone, this is Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC, and today we're talking again about employment rights, employee rights, and we're looking specifically on the limits on the awards that you could win in your employment discrimination case. Last time we talked about the types of compensation that you may expect to be litigated in your court case, but we left off asking a very important question, which was, we left off asking a very important question last time, and that was, if I get fired and have to wait for the courts to handle my lawsuit, can I go and get another job to support myself and my family? The short answer is yes. Not only should you, but a properly litigated court case will generally require that the plaintiff should seek or obtain other employment opportunities. What, did you really think that you were going to be able to have all that time off work while your court case was being litigated? Wishful thinking, but that's not how an employment case works. And that is what this week's discussion is all about. The limits and offsets along with what is called a failure to mitigate. Now, let's look at some limits and offsets. How is back pay limited or offset? I'm sure some of you are thinking that. The main point is that back pay is limited and reduced by the amount of earnings or wages that you receive from another employer during the back pay period. The amount of back pay is the difference between the salary you would have received if the employer had not discriminated against you and the wages you actually received at your new job. So let's look at an example. Acme Company was paying you $60,000 per year before they illegally discriminated against you and fired you. Your new job of like kind is paying you $40,000. When Acme Company is found in violation of the law for discrimination, wrongful termination, whatever it may be, they will owe you $20,000. Makes the plaintiff whole. So even though you were making $40,000 at the new job, you still ended up with $60,000 at the end of the year because the court found in favor of the plaintiff. Back pay offset is the difference in the salary of someone who was discriminated against and then obtained a lower paying job. But what about a failure to mitigate? The main point in the failure to mitigate is that if you plan on bringing an employment discrimination claim, you cannot just sit around and take things easy. A plaintiff who brings a lawsuit against their employer and expects back pay must seek with reasonable diligence a substantially equivalent employment opportunity. And in other words, you cannot be a couch potato. You must take an active role in seeking a new job that is similar to your old one if you expect to get awarded back pay from your original employer. The summary for failure to mitigate is that in order to bring a successful lawsuit against your employer, a plaintiff must seek to mitigate damages by looking for and/or obtaining a new job. Failing to mitigate would mean that instead of going out and getting that job that pays $40,000, you sit as a couch potato and you earn nothing. So some of you may be wondering, do I have to pay an attorney to represent me in my employment discrimination case? Well, the answer is no. You can represent yourself in court, but if you want to feel at ease knowing that you have a trusted attorney fighting on your behalf, then we would suggest you spend some time finding that attorney, putting money down on a retainer, and getting that attorney involved sooner rather than later. Generally speaking, a plaintiff must bear the burden of their own attorney fees unless the fee is authorized by statute or court rule. The good news is that many of the lawsuits filed under Title VII of the Civil Rights Act, the Americans with Disabilities Act, Family Medical Leave Act, Elliott-Larson's Civil Rights Act, Fair Labor Standards Act, and the Age Discrimination in Employment Act allow for plaintiffs who succeed in their case to recover their attorney fees. Some of you may be wondering, well, what about all the stuff before the lawsuit is filed. The example I will use is that a small retainer may be required up front. An attorney may want some money down in order to start working on your behalf, arguing with your HR department, filing the necessary documents that need to be filed so that your lawsuit is strengthened, or they may require a contingent fee or a combination of both. A contingent fee is where the attorney doesn't get paid unless they win the case. Another way, as we just talked about, is that the attorney may say that they're going to file for an award under the statute. Fees awarded by statute. Depending on the type of case it's filed, that may be allowed. So the summary here is that no, you don't have to hire an attorney, but if you do, you should pay them to help you protect your future and stand up for your rights. If you would like to retain Radzwion Law, PLLC as your trusted attorney, do not hesitate to contact us. We are here to protect you when you need it most, and we will fight for your freedom. Thanks for watching.